regulations, that the practice note should be filed. So even if I don't issue such a directive, it should be done. And in a difficult matter, it speaks for itself. But let's leave that issue. You and your attorney can debate it, and I'll give it some more thought in my leisure time.
Yes. Well, we'll also debate it with Mr. Costa because he also said me. But Maliki, on the question of prejudice, an impression is created that the clock started ticking in January 2022 when the order of Justice Miller was granted. And the suggestion is then made that it is from that moment that we should have taken steps to bring a legal application. But now let me submit that that is completely incorrect, because the suggestion is that the order granted by Justice Miller prevented the regulator from doing what he did. If you were to uphold that proposition, then you will have to dismiss the application. But we submit you cannot uphold that proposition. The very first point of reference, as far as that order is concerned, is the notice of motion in the application which goes back to the order of Justice Miller. You will find that
just a moment. Can I ask you to, can your junior auto-direct me on case lines?
Page 1-42.
But can't your junior just auto-direct me, then we'll go quicker? Does he know how? Otherwise we'll have to do it the long way.
Yes.
So you say the page is?
1-42. Yes, page 132. And then we see the notice of motion in that application where there were 3 items.
Are you sure the page is correct? Because mine doesn't move. If I put in one, I see there's, but there's also a full stop. Maybe that's the problem. First, let me see. Still not. 132. 42. I've got it. I think someone auto-directed me.
I don't know why
No, I'm there. I'm there. You may proceed.
Yes. So my lady will see that there were 3 applicants in that application. The first applicant at that point in time had written the 3, and she was waiting for your results. She was in Port Elizabeth at the time. And in her affidavit, she said to the court, I'm concerned that if the results are not published in the newspapers, I'm not going to get them in time. I need to make arrangements to go to the University of the Free State at the time. And then the second and third applicants also made certain submissions to justify the setting aside of the directive. Then page 1-43, you will see then the relief that was sought in that application. Paragraph 2, my lady, of that notice of motion is very important because the applicants at that time sought a general declaration authorizing the publication of Matric results in newspapers. The way in which it is formulated on the basis that it's clear that there is nothing wrong, there is nothing unlawful about publishing Matric results in the newspaper. That's paragraph 2 of the order. But when that order was not granted, and you will see that it was not granted when you look at the order, which starts on page 1-39. But before I go, I must tell you, if that order had been granted, we would not have been here. Because there would then have been a general declaratory order that says it is lawful to publish Matric results in newspapers. But everybody accepts that that order was not granted. And you will then see in the order, my lady, from page 1-39, and the operative part of it, 1-40, and so on. So paragraphs 2.1 and 2.2. So the suggestion that we should then have come to court at that point in time to soon thereafter, is wrong. Then if you go to page 1-41, you will then see the directive that had been issued by the Department of Basic Education at the time. At that point in time, the Department of Basic Education had formed the view, and correctly so, that the dissemination of Matric results to newspapers by themselves was a contravention of the POPIA Act. And that as a result of that, they were then able to disseminate the results to newspapers. That is what gave back to the application, the notice of motion, of which I've just debated, together with the order granted by Justice Miller. The reason why I said it would be important for my lady to have regard to paragraph 2.7 of our requirement is because the beginning of the dispute started from what we said in the draft. My client says the order granted by Justice Miller does not have the effect of preventing them from performing a long list of their obligations. In fact, it would have been wrong if the order were to be read. But what is important, my lady, is that the enforcement notice which my client seeks to enforce was conducted after the order of Justice Miller. It was not conducted before. So before that, this kind of an assessment had not been done. The order of Justice Miller regulated the release of Matric results of examinations that were returned in 2021. There was no parallel. In 2023, the DBE released results for examinations returned in 2022. It is in 2023 that the regulator then started to conduct the assessment, which then gave back to the enforcement notice and the orders which we seek to enforce today. We submit that, again and repeat, if you found that the order of Justice Miller prevented my clients from conducting the assessment, then we lose the application. But it cannot be so, because if you interpret it in that fashion, it would then mean that it prohibits the regulator from conducting its statutory function, which was not even provided for in the notice of motion and the funding. But what is most important in this case, Section 1891 of the POPIA.
Just let me get to that. Got it?
So, So Section 1891, my lady, empowers the regulator to conduct assessments. So Section 1891 provides that the regulator, on its own initiative or at the request by or on behalf of the responsible party, the subject, and so on, must make an assessment in the prescribed manner of whether an instance of processing of personal information complies with the provisions of this Act. So in 2023, my client invoked that section in respect of the results that were published in January 2023. And this is another reason why the order of January 2022 is completely irrelevant. So then they conducted the assessment. They prepared a draft report, sent it to the DBE for comments. The DBE submitted its comments, I think on the 31st of January 2024.
Just when was the draft report released to the DBE? I can't remember.
I think it was released to the DBE in November of 2023.
Wasn't it the 27th of November? Or am I incorrect?
27 November 2023.
Yeah,
Yeah, it may be right.
27 November.
Yes, it may be right. But what is more important is that the DBE commented on the report. They responded, they said, no, you can't do this, you can't do that, and so on and so on. But at the end of the day, the regulator had to take a position, having considered the comments of the DBE. The regulator then issued the enforcement notice, which is now in dispute.
The date of the enforcement order?
6 November 2024. My lady will find that on 21.
Was it 6 November or 6 December?
No, 6 November.
The enforcement order, 6 November. Yes?
That is when the assessment notice is issued.
You should not try and kill your opponent, Mr. Swanik.
Maybe page 147, maybe we'll find the identity is now properly connected to a direct to the page.
Just a moment. Yes.
So the enforcement notice is issued on 6 November 2024, and then it is submitted to the DBE together with supporting documents. It is common cause between the parties that the transmission of the assessment report together with the annexures to it was completed around about the 18th of November 2024. That is when the enforcement notice was submitted on the 18th of November 2024. I don't know if Mr. Pastor was to So the enforcement notice, on page 147, it sets out the findings made by
And the case lines,
page 1-47.
yes.
On page 1-48, my lady will see the conduct complained of by the regulator because it is highlighted. And it was a breach of the conditions for the lawful processing of personal information. And all of that is set out in the next pages up until paragraph B of the having made the findings which the regulator made, amongst others, that you published the 2023 results, for example, without the consent of the lenders, that is in breach of section 11(1)(a) of POPIA, because there was no consent. So the regulator made that.
I just want clarification. If I remember correctly, the paper says that this time around, the matriculants had an opportunity to either consent or refuse consent. So, what do you say about that?
Well, if they want to publish, Mr. Boston,
it was intent the system in place, but for logistical reasons, the system was not completed, it was not effective, so it could not be reliable.
So they could not consent, or so that averment is not correct on the papers.
My lady, we now continue with that.
Yeah.
We expressly state that we don't rely on consent, but we rely on the other provisions of section 11.
Then, Mr. Tatwani, you don't have to deal with that.
that's it. And I will address it in detail. The mere fact that there was an attempt to obtain consent against the clear indication that the order of Justice Miller is irrelevant for the purpose, because if it was relevant, that attempt would not have been made at all. Then, page 1-53, that is where you will find the orders which the regulator issued. Paragraph 1, they said, you must give me an undertaking within 51 days so that you will not publish the results in newspapers. Then 2, you must not publish the results other than through your normal platforms, your SMS platforms, and making them the results available to the learners at the schools at which they cite for the examination. Those are the 2 orders that are of concern for present purposes. And for my lady to enforce those orders, my lady doesn't have to interpret them. My lady doesn't have to go there. What we say in the Bible is that those orders exist in fact, and they exist in law, and until such time that they are set aside, the DBE must comply with them.
But what about, I know there was a problem by the DBE. They did file an appeal.
Yes.
They were out of time.
Yes.
They say in their answering affidavit they're going to seek condemnation for that. So another court may grant them that condemnation.
Well, my lady,
And is your argument that this court should ignore that appeal just due to the fact that it was filed late?
well, my lady, not only you must not, but the DBE itself accepts that there is no appeal at this point in time.
Yes, because
That
I
is
haven't,
why they said-
but I understand the context of
Yes.
that admission to be, we accept that we still have to get condemnation.
Correct.
At this stage, if I remember correctly, the papers say we don't know what went wrong in the State Attorney's office.
Yes.
And we can't say now, but there is an investigation. So once we approach the court for the condemnation, we will explain. That is how I understand the
Yes,
context.
but, my lady, that is exactly as far as it goes. But just on what they said, right on what they said, you cannot then say on that basis another court may find for them, because there's still no explanation. There may be an explanation.
Yes, but
for now, there is-
but in the absence of an explanation now, I know they quite directly say we don't know what went wrong.
Yes.
So I can't prejudge that and say they won't get condemnation,
Correct.
because they may have
Yes.
a suitable explanation in due course.
Yes. But for now, until such time that they get condemnation, that appeal is not before the court.
Now, obviously, it's not before me,
Correct.
but I can't ignore the fact that there is a pending appeal or a pending appeal that might be entertained in future.
Correct. Well, Malady, let's accept for purposes of now that another court may grant the condemnation. It is only at that point in time that the question whether or not the enforcement orders are suspended or not suspended will arise. But at this point in time, the orders are not suspended. That's our case. And there is ample authority for that proposition, even as far as your normal notice of application for leave to appeal in this court is concerned. I think there is a judgment in Panayoti versus Matric where an application for leave to appeal was found out of time, and the court concluded, and correctly so, that it did not have the effect of suspending the order.
But I don't have to consider that. But
Correct.
if I consider the application before me, I certainly can't ignore the fact that an appeal was filed. Whether they will get condemnation will be for that court to decide.
Correct. That we agree with. And that is why in both our answering affidavit and our refinement, we have addressed you fully on that question. But then, Malini, two orders that have been granted are issued, and the DBE had a period of 31 days to comply therewith.
Well, they explain the one thing that I need you to address that regarding the question of urgency. The facts are that in 2022 and in 2023, the Matric results were published in the manner that was prescribed by Judge Miller.
Yes.
So now we're sitting, when I consider the question of urgency, at that stage, the compromise was made to say, listen, we're only going to publish the examination number as well as the results. Now, I know there's a whole issue whether that is identifiable or not identifiable.
Yes.
But what I don't understand, if it was done in those 2 years, what is the prejudice that matriculants are going to suffer if it's done this year? And just in the context, because on a reading of the POPIA Act,
Yes.
I became very aware that a lot turns on the interpretation of the Act, and I don't know, is there any authority on exactly what the information regulator's powers are? I didn't have time, seeing that's the urgent court.
Yes.
And I'm, at this point in time, not quite sure how far her powers go, as well as the question of how the enforcement notice should be interpreted. So, and I don't think the urgent court can go there, and that's why I don't want to go in the merits, because I think it's more complicated than that. So I'm concentrating at this point in time merely on the question of why an urgent interdict should be granted to stop a practice that's been in existence for time immemorial, and since 2022 at least we know that certain cautionary measures were put into place to protect the identity of matriculants.
Yes, well, the answer to that, my lady, is not. It's a simple one, and it is short. After 2023, an assessment was conducted to determine whether that conduct violates the legislation. And the regulator found that it does.
But ultimately it will be for a court to decide whether the information regulator is correct in her interpretation of it. Is
But
that not correct?
That is in the appeal.
Yes.
That is in the appeal, and the counter application, which I will address you briefly if you allow me. Because
Mr. Pelser, I might have caused this deviation. We're dealing with urgency, and I'm very well aware that we're dealing with urgency, so you can trust me on that. I will limit myself to what is urgent. I realize that in a matter like this, some aspects of the merits may be mentioned, but trust me, I will ignore it as far as the urgency is correct, but I just need to understand the context.
I trust your judgment.
Thanks, Mr. Pelsi. Yes, then, Mr. Satswani.
So, I was saying that the answer to my lady's question is simple, because all of this arose from the assessment that was conducted after the publication in January 2023.
And in the appeal, that will be decided.
Sorry, my lady.
In the appeal, if it is allowed and the condemnation is granted, this issue will be determined. Am I correct?
Yes, that is correct. But we're raising this now, obviously, in the context of whether or not
It's urgent.
Correct.
Yes.
So after that assessment was conducted, that is when the enforcement notice was given together with the two orders to which
I just want to understand your argument. So you're saying the matter became urgent only after the assessment?
Well, the
What's
matter
about
became urgent when the DBE refused to comply with the orders that are referred to, I think, page 141 and 48 on case law. That is when the matter became urgent. You have seen in the regulators and the regulator plays open counsel. The regulator says, all along, I was under the impression that the DBE is going to appeal my orders. And the reason for that is because that's what they've been saying in the media. They said, no, we're going to appeal and we're not going to comply. So the regulator waited for the notice of appeal to arrive. And at that point in time, the regulator could not come to court on an urgent basis for two reasons. One, it could not have ignored what the DBE was saying in the media space, that it was going to file an appeal. Two, the time period for the DBE to comply had not yet arrived. That time period only arrived on the 19th of December. That is when the DBE was required to institute its appeal.
The DBE says in their papers that the regulator must have been well aware that this is the most busy time in their department because it's got the matric result, the matric examinations, so they're busy with all of that. So the one explanation that I can't find in the perusal, and maybe you can assist me, is why only file the assessment in November and then expect on an urgent basis that the practice that has been applied in the past is going to be prejudicial to the matriculants?
Well, Madam, that time period is fixed by statute. Section 97 is the one that makes provision for an appeal within a period of 30 days from the date on which the notice is served. And the regulator did give them 31 days. It must have been, should have had 30 days within which to comply. But, my lady, if you have regard to what the DBE had to do, you will see that it could not have been affected by the fact that someone mustn't be preparing exam results. All that they had to do was to file and serve a notice of appeal. That has got nothing to do with examination.
Well, they did file, but out of time.
Correct. They filed, but they did not serve.
How long were they out of time?
I think they were about 7 days out of time. So, from the 20th of December, again, you will have seen the regulator's letter to the Minister of DBE to say, I read in the press that you have filed a notice of appeal. We have not received it. And so far as we have not received it, we are proceeding now on the basis that the enforcement notice and the orders have not been suspended, because the appeal would have suspended the orders. But there wasn't. And you can see from the regulator's letter and the regulator's affidavit that the regulator had resigned itself to the fact that if an appeal were to be instituted, the orders would be suspended and they would be entitled to publish the results. But they didn't suspend them. Then the minister didn't respond to the letter, and on the 24th of December, the DBE is reported to have persisted with its position to say, we are not going to comply with the orders of the information regulation. And whether any serious regulator will be concerned if another organ of the state publicly says, I'm not going to comply with the orders of that organ of the state.
You know, I'm sorry to interrupt you, but before I forget.
Yes.
An issue that is of some importance to me is the requirement, constitutional requirement for government departments to work together and to avoid litigation.
Yes. Well, that is Section 41 of the
Section 41 of the Constitution, yes. Yes.
But that section, maybe, it doesn't apply to Islam. It doesn't apply to constitutionally independent organs of the state. There is a
Is there authority to that?
Yeah, there's a section that I will give it to you. That gives you the application of the
So you say, I just want to understand what you say about the standing of the regulator. You're saying she does not form part of government?
No, I'm not saying that. We're saying the legislation, the Intergovernmental Framework Act, makes provision for its application, the institutions to which it applies and institutions to which it does not apply. And it excludes constitutionally independent organs of the state, such as my client. So we submit that, and perhaps that is why the issue has not been raised by DBE. But again, in any event, the letter by my client on 20 December directly to the minister was
on which date was it sent to the minister?
It was sent to the minister, Matric.
On which date?
On the 20th of December.
I think if I remember correctly, the papers say that due to the time of the year, it didn't come to the attention of the minister. Isn't that reasonable?
Well, it is reasonable, but it was obtained. As on the 24th of December, the minister must have received it. But it no longer matters, because someone who speaks for the DBE spoke for the DBE on the 24th and said, we are not going to comply. And we submit, my lady, that a serious regulator would have been concerned. And even this court should be concerned by an organ of the state saying, I'm not going to comply with processes of another constitutionally independent organ of the state, particularly one that performs the functions vested upon my client.
The one thing, and I'm sorry to deviate,
Yes.
The one thing that you haven't addressed to my satisfaction is the question of prejudice. You know what I was thinking?
Yes.
When I read the papers the previous year, that applicant said she was in Kabarka, if I remember correctly, and she would not be able to obtain her matric results by attending to the school.
Yes.
Now, the solution that the regulator states in the papers is you should go to the school or there is an SMS line.
Correct.
But what about the millions of matriculants and parents, especially, who don't have access to a phone and an SMS line? Won't they be prejudiced? It's something that in the long run, with a proper investigation, might be investigated. But if you're somewhere in a village or without connectivity and far away from your school, isn't the prejudice then much more or a greater possibility for the majority of matriculants in this country?
Well, my lady, if one is concerned about those learners in the villages, to use my lady's example, then one will expect that they are going to be at the villages at this point in time, and they attend village schools.
We
The
don't
results
know.
will
We
deliver
don't
there.
know that.
Well.
We can't accept as a fact. And I think I can take judicial notice of that. That all learners have access, or the ability, or the financial means to go back. And not all of them are studying in the village school. Some of them live with their family in the cities to attend school here and go back over holiday periods to their families. And as we know it, a lot of our people are impoverished.
Well, but then is
So
my
they
lady,
can go to the shop
yes.
to get the paper.
But is my lady then assuming that they will have the means?
I'm assuming nothing. I'm doing exactly what the regulator is doing, to say, well, you've got an SMS line, you can go to the school. And I'm just stating a fact of our country.
Well, my lady, can I take you to page 3-24?
Page
Because
3-24.
3-24, because my lady will find the answer to that. And this is the consent form which the DBE,
Just read, sorry, please.
page 3-24. So my lady will see that this is the consent form which the DBE issued to the learners. There are two issues that are important as far as this form is concerned. The first one is not the one that answers your question, but the second one does. The first one is that the DBE, by issuing this form, accepts that the dissemination of matric results by issuing examination numbers to newspapers does contravene POPIA, and for that reason, they needed the consent.
I'm
The
sorry,
second
for a reason I don't understand. Maybe I've got the page wrong.
Yes, page 3-24, my lady, It's a form of the Department of Basic Education. I don't know if my lady has got it.
Just let me try again.
3-24.
I've got it.
Is my lady there?
Yes, I am.
Yes. So that is the consent form which the DBE wanted learners to sign to consent to the release of their results to newspapers. I said to you, my lady, it highlights two very important things. One, it highlights the fact that the DBE accepts, and correctly so, that the publication of results by releasing examination numbers requires consent. And you will see that that is the very first item for which they required consent. That is the publication by of examination numbers in the newspapers. And the second consent, my lady, is by making results available to the SMS service. These are the services which have been designed and made available by the DBE. So we submit, my lady, cannot now second guess that the people to whom this notice was issued will not have access to it.
You
But-
know,
but-
you
but-
know what?
Yes, ma'am.
What became apparent to me on reading this
Yes.
is that this is a developing policy that will have to take into consideration the realities of our country and the abilities. So, seeing that the POPIA Act is relatively new and we have certain constraints in our country, I understand that this may be a way to go about it in future, but certainly it doesn't mean that the court can ignore the realities of this country.
Well, my lady, no one is making a big issue about those type of realities in the papers. Before.
I know, but
And
are you
we
saying I can't raise it?
Sorry, my lady.
Are you saying that I can't raise it from the bench?
Well, we submit not in the context of this case because all of that is sought doesn't go further than to simply say that there is an enforcement notice and the DBE must comply with it. And the DBE itself does recognize that one of the methods of disseminating results to the students is through the SMS line. The DBE remains responsible to make the results available. And it is not the DBE's case that there is a long list of students who are not going to obtain the results unless they are published in the newspapers. That case has not been made, and it just cannot be made. It may very well be that we may think about one or two people who may not be able to buy a newspaper or go to school on a particular day. But that is not necessarily the case before you now. The case before you now is a very narrow one. There is an enforcement notice. It contains two orders. Until such time that it is set aside, it must be complied with. My lady has written many judgments on that.
Sorry, Mr. Tsatwani.
Yes.
The status of the enforcement notice
Yes.
is my prima facie view this court should not pronounce on at this point in time. It's the question of urgency, whether it's urgent, because the status of the enforcement notice may be subject to extensive legal debate
Well, my lady.
in due course.
Yes, my lady. You don't have to pronounce on the status of the notice. The law has already done that for you. It is enforceable and it must be complied with. You have written judgments on that principle yourself. And that's why, as of argument, you will have seen we restrained ourselves from giving a public lecture on that principle. It has been restated, reformulated, repeated 100 times by the courts. We have said that, as a argument. So you don't have to go there. So then, my lady, on the 24th, the department said, we're not going to comply with your notice. And we submit that that is when the trigger event for bringing the urgent application happened. It was on the 24th of December when the DBE said they are not going to comply with the order. Then, as you now know, the urgent application was then served, and everybody tried their best to file papers on time, which allowed all the affidavits to be filed by Thursday before the hearing. So you now know that the results are going to be published on the 13th of January 2025. And we submit that if the relief that we seek is not granted today or before that date, then the regulator could not obtain substantial redress at a hearing in due course, because by then the results would have been published, and the orders which it had issued together with the enforcement notice would have been rendered meaningless by another organ of the state. So we submit, my lady, we have made these submissions in paragraph 5 of our as of argument, why we say the matter is urgent and why we say the regulator could not obtain substantial redress at a hearing in due course. We submit we have complied with the two requirements in Rule 612 as far as the hearing of the application on an urgent basis is concerned. The answer from our learned friends is simply that the agency is self-created. We submit, my lady, that there is no merit in that proposition, because that proposition, my lady, is based on the order granted by Justice Miller in January 2022. And I have demonstrated to you that that order does not have the effect of preventing my client from conducting the assessment which it did. And unless that is challenged, which is not the case, we submit, my lady, that the regulator was correct in acting in the manner in which it did. And we submit, my lady, that a proper case for agency has been made.
Thank
and
you,
we
Mrs.
then ask, my lady, to entertain the application on an urgent basis. As it please accordingly.
Thank you, Mrs. Sitwani. Mr. Oosthuizen.
Lady, there is a clear link between what was authorized by a court order by Judge Miller in January 2022 and today's proceedings. Today, the information regulator, after more than 3 matric examination rounds were published, because remember, in January 2022, what was published was the Matric 2021 results. Then, in January 2023, there was another publication of the 2022 results. And then, in January 2024, there was a third publication of the results of the Matric examination in 2023. So, under colour of the court order of your brother Miller, that which the information regulator today seeks to interdict was authorized by Miller. The very same conduct. There's no difference. It is the same conduct, publishing the examination numbers together with the results. Now my learned friend says, no, wait a minute. Let's be selective with the facts that we look at. Let us only look at what happened now in December. We issued an enforcement notice. They tried to appeal, and then they made a media statement, and that triggered the urgent application. But that is an opportunistic and a selective approach to the facts. You have to look at all the facts, because this situation, the situation that arose December last year and this week, that situation was manufactured, it was created by the information regulator. They knew what order was made by Millard J in January 2022. They were cited as a party to that application. The uncontroverted evidence shows that they were part of the process agreeing upon that court order. Their input was required, they gave their input, they didn't object, they knew about this court order. And that court order is also binding upon them. Now my learned friend comes and he says, but wait a minute, look at prayer 2. Look at prayer 2. There was an application to ask for a declaratory relief which was never granted. Ergo, the issue that we find in that prayer 2, the lawfulness of the publication, has never been decided by Millard. Now, my lady, every advocate goes through a course in drafting. And I thought this was trite, but I had to go back to the book of Van Blerk on legal drafting, which was published in 2015, and it is Van Blerk's book on page 27, paragraph 4.23. What this paragraph says is that, remember that you can ask what you want, but a court is not going to grant more relief than is necessary. So what do we teach junior advocates when we get to, for instance, applications for review? The first prayer is a declarator. You ask for a declaratory order. The second prayer is to review and set aside the impugned decision. But when you get to court, you don't ask for both prayers to be granted, because if the review is granted and the impugned decision is set aside, it follows that it was unlawful. You can't grant the second prayer.
Mr. Oosthuizen, sorry to interrupt you at this point. I just want clarification. I understood the papers, and I might be wrong, that there was a settlement in any event.
That there was?
A settlement pertaining to the court order.
Yes, my lady.
So whatever you asked for at that day is actually irrelevant.
Yes, my lady.
The parties came to an agreement.
Yes, my lady.
And if I understand the papers correctly, the information regulator was a party, wasn't there, filed a notice to abide, but was consulted.
Yes. And provided input.
And provided input on that order.
Yes, my lady. Now, what I'm saying, my lady, is if you go and look at the orders that were made by your brother Millard, that order that he made in paragraph 2 could not have been made unless it was premised upon the lawfulness of that conduct. Yes, there is no express declarator, but the order itself cannot be given unless the judge was satisfied that that conduct is lawful.
In any event, am I correct, Mr. Oosthuizen, if there is a court order, it is regarded as lawful until set aside?
That is precisely the point, my lady. Although at this point in the argument, I will carry on from this point onwards, but let me just read to you from this book of Van Blerk. He says, for instance, if a plaintiff claims an order declaring a particular agreement to have been cancelled, or even that it's been breached, and at the same time a monetary or other relief, judgment following on such a finding, A declaratory order concerning the status of the agreement or that there has been a breach, therefore, would ordinarily be unnecessary. The point that I make is, my learned friend's argument is that because nothing has been said expressly in a declarator about unlawfulness, therefore the issue is still open, is simply wrong. It is not so. The fact that there is an order which authorizes this conduct makes it lawful. It made it lawful in January 2022, it made it lawful in January 2023, it made it lawful in January 2024, and it will also make it lawful now in January 2025. Now, if the information regulator was concerned about this, they had all the time in the world since 2022 to do something about this court order. They elected not to do so. They accepted that court order through their conduct.
Mr. Tsitswane indicated that on a reading of the order, if I understood him correctly, that it does not have any effect on this year,
On?
on the publication this year.
Oh, my lady, that... Okay.
I might have misunderstood him. I'm quite sure he will
My lady, that
indicate.
may be his argument, but that argument raises a different set of issues. Because now, one has to interpret the court order. And if you look at the court order, there is no limitation as to time. The court order does not say that it is for January 2022 or for 2023 or 2024. It is not limited in time. The court order, in effect, orders the department to carry on with the historical approach, but it then adds a caveat in paragraph 2.2. And it says in that caveat, this publication continues, but you cannot publish the personal names of the learners. So carry on as before, but leave out the names. You can't publish the names. Now, on that interpretation, this court order was followed without objection for at least 3 years thereafter, and the information regulator did nothing. Now, my learned friend was also a bit economic with the dates concerning this assessment and enforcement notice. He says, well, the assessment starts after the January 2023 publication. And then the assessment took them about a year. It took them a year to make an assessment of the legal situation, because they had all the facts. They had all the facts. They knew what was going on. So they started in January, after January 23, they started with an assessment. It took them a year. And in November 2023, they provide us with a draft report. We replied to that, and it was given to us in November, just before the Christmas holidays, but on the 31st of January 2024, the Director General of the Department replied to their draft report. Now, from 31 January 2024 until the letter of 6 November 2024, nearly 10 months later, they don't tell us what happened, what they did. They simply took 10 months with no explanation. Then they issue an enforcement notice, and they issue it again just before Christmas and the traditional holidays. Now, we say that if you look at this totality of facts, then there is no urgency in the matter. They have created this urgency themselves by sitting back and ignoring the court order of Miller as if that court order is not binding upon them. Now, my learned friend, in passing, my lady, my learned friend make an astonishing submission. He says, but you must now interpret that court order. And if that court order stands, the regulator is bound by it by then, but then the unhappy consequence is that the regulator would not be able to exercise its statutory functions. I don't understand that submission. The regulator is a creature of statute. It is an organ of state. It is bound by the Constitution. It is bound by the rule of law. And if a High Court of this country has decided that the publication of that anonymized format Matric results is lawful and can proceed, then it is not for the information regulator 3, 4, 5 years down the line to come and second guess such a court order. And then, my lady, one of the complications of this case is that, and I speak for myself, but I think I also speak for my colleague, we had to prepare an answering affidavit in 1 or 2 days between Christmas and New Year, at the busiest time of the year when most of the officials were either not available or on leave, when the attorney's office was on skeleton staff. It was difficult to do it, but because of the importance of the matter and to assist the court, we did our best. But in the process, not all of the history is before the court. And the court spoke about an urgent court having to interpret a law as difficult as this. Now, my lady, let me deal with that very quickly. The POPIA Act is the result of an investigation by the Judicial Research Commission that took a number of years, not a few weeks or a few months, it took a number of years. The POPIA Act drew, and it is informed by 3 international instruments. So in order to really understand and interpret POPI, you must have access to those international instruments. The one instrument is known as the OECD Guidelines of 1982, I think. Now, the OECD is an organization, an international organization, that was created in the wake of the Second World War to look at the redevelopment of Europe after the destruction that was caused by the Second World War. In time, that organization changed its name and changed its vision. It became an organization, an international organization for basically first world countries that are 1, committed to democracy, and 2, that are committed to free trade. These 39 countries then come together and they have workshops and they say, what problems do we have in common? And what guidelines can we issue? We can't establish international law, but for our members, we can give guidelines so that they can develop their democracy and they can develop their own economy. So this OECD guideline of 1982 then saw the light. But the background to that is the following. The OECD realized that for purposes of international trade, personal information have to cross boundaries. And they were concerned that that would expose the individual to the danger of an invasion of his privacy. So, in order to promote international trade, that was the main purpose. In order to promote international trade, and in order to allow for the free flow of information, they had to put a caveat on this. They have to put in safeguards to protect the individual. And that is where the so-called data privacy laws come from. Now, the 8 guidelines that were developed by the OECD, those are the 8 conditions that you find in Chapter 3 of our legislation.
I don't think we should go too much into this, but
Okay, my
if
lady,
I understand, you just stressing the point that I've made, that this is no easy act to
No.
interpret.
and I've only mentioned the OECD now, my lady. I won't
Yes.
go into it, but I will mention.
There's the other problem that I see in the interpretation at this point in time, that it's also not relevant for today, but there is the tension that's been pointed to in the answering affidavit between the Schools Act and the duties on the DG and your client to provide information. And
Yes.
then there's also the third issue, and that is the free flow of information. So if we limit certain rights, we can only do it within constitutional parameters.
Yes,
So
ma'am.
it's no easy task
No.
to determine how far this act goes, and that's why I don't
Yeah.
think this court can even attempt.
My lady, I've already mentioned the international
Yeah.
instruments. There are 3 others. There's a European Convention, a European Directive, and a European Regulation. All of which have drawn comments from various international courts. Then there's the constitutional dimension that you've mentioned yourself. Then there is the very preamble of POPIA, which explain how it tries to bring these conflicting interests together. And then there's the fact that there are no reported judgments, and to the best of my knowledge, also no unreported judgment explaining the scope and ambit of POPIA. There are 2 reported cases in which there was a fleeting reference, without any discussion and without any comments, on certain sections of POPIA, but nothing that can be of use. My lady, I was involved in January 2022, and since then I have started the file in which I collect everything that is published on POPIA, and there are a few academic articles published. Some of those academic articles is by a lady called Annelie Roos.
But I can't go into that now. So for purposes of urgency, you refer to it just to illustrate that it's no easy matter.
This is not for an urgent court. This matter is not for an urgent court. And when my learned friend says that we only say that the urgency is self-created, my lady, we say that on the basis of all of the facts, not only based on the events that happened in December 2024. My lady, then on the question of urgency, would you please allow me just to check my notes? Yeah, my lady, I must, in order to prevent any misunderstanding, I must deal with the appeal
Yes.
that was done. Now, my lady, all that Section 97(1) says is that if there's an enforcement notice, you can appeal to a court within 30 days. There are no prescripts on how this appeal is to be prosecuted. This isn't an appeal in terms of the uniform rules of court. This isn't an appeal in terms of the Magistrates Court Act. In that context, there's a lot of authority that says that upon a proper interpretation of those legislative instruments, an appeal is noted once it is served on the other party and filed with the court. But there are no such prescripts in the POPIA Act. And in this case, our appeal has been filed before the expiry of the period. We accept that the service may have been late. And the suggestion that we don't have an explanation for that is also wrong. The client's explanation is that something went wrong in the State Attorney's office, pointing the finger to the State Attorney. Precisely what went wrong we still have to determine, but there is an explanation before you. We did everything that we could have done, and we've done it in time. We've done it so in time that it was filed with the court on the 17th of February, 17th of December. I apologize. The question now is whether a late service means
When was it served?
it was served on the 24th of December by the sheriff.
How many days was it late?
That is 5 court days, 7 calendar days, my lady. The question is now whether that means there's no appeal pending. Now, my lady, in the replying affidavit, the information regulator, on at least 3 or 4 different occasions, in 3 or 4 different paragraphs, states under oath that as far as she's concerned, the appeal is pending. There is an appeal and it is pending. If I can, if you go to my heads of argument, my lady, you will find this in paragraph 3.5. Can I take you to the record, page 1-85? And more specifically, can I take you to paragraph 5.3 on that page?
I find the page doesn't seem. Oh, thank you for whoever did that. I've got it.
Okay. In paragraph 5.3, it says in the second sentence, the DBE's attempt to raise a collateral challenge to the order is not competent in circumstances where the DBE, according to it, has already filed an appeal which remains pending in this court. Then on page 188, 2 pages on, in paragraph 6.2.2, on the DBE's own version, it has already instituted an appeal which remains pending in this court and in respect of which it is going to institute a condemnation application for the late institution thereof. 6.2.3, there is already a pending challenge to the orders. And then also, next page, paragraph 6.4, 1-89, it is accordingly not competent for this court to entertain the collateral challenge in circumstances where the very same challenge, based on the same facts and legal issues, is pending before the same court as an appeal. Now, my lady, I've always heard people say that you cannot have your cake and eat it. That's wrong. You can have your cake and then eat it. But what you cannot do is you cannot eat your cake and then have it. It's either the one or the other. They are trying to sit on 2 chairs. So, for that reason as well, the submissions with regard to our appeal is incorrect. My lady, I've already made my submissions on urgency. Can I just check with my junior?
Yes.
My lady, those are our submissions, unless there's anything with which we can assist you further in this matter.
Thank you, Mr. Westhuizen. Mr. Pelser.
Please the court, my lady. I will not be repetitive of what Mr. Oosthuizen has submitted to your ladyship, but I certainly go along with what he has stated and argued. There are one or two other slants which I want to add to what he has stated. The first is, my lady, the counsel for the applicant says that the train that resulted in the enforcement notice was set in motion by the 2023 Matric results. And my learned friend has already pointed out to your ladyship that no, in January of 2022, the present applicant was part and parcel of those proceedings and consented to the order. So it takes the court back 1 year before 2023, but it actually goes back even further. In the enforcement notice which is before court, November 2024, there's repetitive reference to the fact that during November, December 2021, before the judgment of Judge Millard a month later, there was interaction between the regulator and the department regarding exactly this problem. It goes back to the end of 2021. And then, my lady, small wonder that in 2022, and as a result of a threat by the present applicant, that was his stance. What was about to happen in 2022, and which he didn't like, there was a threat to which the department acceded and said, well, I think I will go along with your threat. I will adhere to what you are saying. And then, at that point in time, the department said, in the result of this threat, I'm going to not publish. And then the regulator made a perfect about turn by sanctioning what has happened, by sanctioning the order. So, my lady, at the very least, and because of this threat, at the very least, and even though there was an order to which the regulator has acceded, the regulator must have been extremely unhappy with what has happened, because he's made a threat, the department listened to what he said, and now he was thwarted by an order to which he has consented. So he must be very unhappy at that point in time. Then he takes it 1 year before doing anything at all. The applicant relies on the beginning of 2023. He says that is when the investigation, the assessment commenced. It may be that in fact it happened at that point in time, but he was going along with what he has consented to for a full year without lifting a finger. My lady, against that background, I should just immediately say this. If your ladyship goes to paragraph 7 of the founding affidavit where the applicant deals with urgency, that paragraph is pivotal. That is what he actually, when he launched the application, relied upon. In that paragraph he says, the problem is, in December there was no proper response and I had no option because January is coming and publication will happen on the 13th of January. That's what he tells the court. He elects not to say a word about the 3 years that has passed. It's obvious why he didn't do so, because that would thwart any reliance on the part of the applicant on urgency. Not a word. So, my lady, then things carry on, and then come, as your ladyship has rightfully pointed out, January 2024, January 2024, there's a response by the department, and then it again took him 11 months, 10 months, 11 months, depending on how you calculate it, before he did anything at all. And your ladyship should bear in mind in this regard, there were no new facts. My learned friend has mentioned that. All the regulator had to do is look at the Act and look at what the department wants to do, and that is all he indeed eventually did, and interpret those two documents and say this can't be tolerated, it's in conflict with the Act. So what he was doing, there's no evidence of a toing and froing between the regulator and certain institutions or individuals or whatever that may have taken up some time. There's no indication of such. All he did is she sat in her office and thought about this and continued to think about it and continued to think about it for 10 months, and then come the end of the year, she said, now I must do something because January 13 is fast approaching. That should not be tolerated by this court. Not, as your ladyship has pointed out, in a matter of this nature. This is a momentous application. It, on certain construction, reflects further consideration. Even so, I must mention that I agree fully with the, let me call it, merits which my learned friend Mr. Oosthuizen has argued. So if it has to be adjudicated, it must be adjudicated properly, not with 3 days a notice in respect of an answering affidavit and heads of argument on the interpretation, as your ladyship has pointed out, on the interpretation of statutes. It's a difficult thing, this. It necessitates the attention or it necessitates proper adjudication. I must mention to your ladyship that during the, or even before the court commenced, I think that during the first adjournment, my learned friend Mr. Oosthuizen, with my consent, conveyed to the applicant's advocate that should the court do no more than strike this application from the roll because of a lack of urgency, and it follows that it can proceed, that in those circumstances and after further documents has been exchanged, the respondents are quite willing to approach the Deputy Judge President for a preferent date so that it can be properly adjudicated before the next Matric examinations at the end of 2025. That is the, I would call, sensitive approach on the part of the respondents to this problem. But that sensitivity is perfectly absent from the approach of the applicant. And my lady, it may be a tall order, but if your ladyship takes into account what the applicant has done, we submit, my lady, that it should be, if your ladyship strike it, it should be struck from the roll with a punitive cost order. There was
Mr.
never...
Pelser, seeing that it's the urgent court and seeing that the circumstances of this case, you will have a hard time at this point in time. I can either grant whatever happens, the successful party, the costs, or I can reserve the cost for the determination of the scale. So, but you can consider that in the meantime.
My lady, I submit a bird in the hand is worth two in the bush. So I wouldn't suggest that your ladyship do that, but will your ladyship consider to reserve the basis on which it is to be taxed? Because, my lady, I would desperately want to argue more in that regard, and I know this is the urgent court. Your ladyship has spent just about the whole morning on this when it didn't justify, when it was dead in its tracks from the outset.
We'll see about that, Mr. Pelser.
We'll see about that.
I keep an open mind at all times.
Very well, my lady. Yes. My lady, if your ladyship will will afford me an opportunity.
Mr. Pelser, there's the one aspect that nobody has really addressed me on, and that is if I weigh up prejudice. What is the prejudice for? I think Mr. Oosthuizen is not so much the prejudice, but his client has got a statutory duty to comply with, and that's why he wants to do that. If I look at this, the only parties that might have that it can be prejudice is the matriculants themselves, probably. Mr. Tsitswani will address me, I think, again on that issue, and your clients. And if I look at the prejudice, if I look at the rights of your clients specifically, why would it be prejudicial for them if I should decide that the matter is urgent, and if I decide after that how I will decide the merits before the 13th of January, I'm still a little bit concerned about seeing the complexity of the matter, but if I have to do it, I will do it.
My lady, regarding the prejudice, I submit that the prejudice that may be suffered if the applicant is correct is that a number or that the matrics will have their information published next to their examination number, not their names. That, my ladyship, I suggest is negligible, particularly so because the applicant did not care to do some kind of census. Your ladyship doesn't find in his enforcement order a single reference to the number of matriculants that may be prejudiced or may be dissatisfied.
I'm going to ask Mr. Tsitswani to address me on what I know on the papers about the nature of the assessment. And if it requires an answer by Mr. Oosthuizen, I only thought about, well, I initially thought about it, but I didn't raise that with Mr. Tsitswani.
My lady, may I say that the prejudice will be level with the prejudice that was suffered in 2022, and there was no uproar, and the prejudice suffered by matrics in 2023, and there was no uproar, and the prejudice that was suffered in 2024, and there was no uproar. There's no evidence of a single complaint. So if I say there was no uproar, the only thing that happened is that the applicant, at his leisure, taking 3 years' time, thought I should rather correct this thing. And then 3 years down the line he thinks, yes, now I'm going to correct it. So if there was an uproar, if there was real prejudice, if there was a big problem as a result of the publishing of the examination numbers, then a prudent applicant, which your ladyship should presume, would have stepped forward and said, I must stop this thing. It's in the public interest that I stop this thing. Never mind individuals. So the prejudice that the applicant will suffer is he will have to wait a little longer. That's all. There's no prejudice to the general public at all. It's only examination numbers that are concerned, and my ladyship would recall that your ladyship has put out the fact that whether that is identifiable is another question. Well, our argument is that it is identifiable only if the matriculant has communicated his examination number to whoever his parents or his girlfriend or whatever, then they would approach the basis on the matter on the basis that he has waived his right to privacy. It happened 3 years in a row without any consequences. There's no prejudice. In Afrikaans, this phrase came to mind, or I can translate it, the heavens won't fall, my lady. Certainly not. Now, my lady, if I can go from there and just look at further notes. I'm just being... Mr. Oosthuizen has drawn my attention to the following. My learned friend for the applicant has argued that once it has been published, it cannot be undone. The answer to that is, my lady, yes, it can't be undone. No doubt about that, even though it will be of limited consequence if it is published. But the answer to that is, there are other consequences, and that is, if he is so certain about this case, he can lay a criminal charge. He's already raised a 5 million rand penalty. And those are the alternative remedies that are available in the context of final relief. We submit, my lady, that those remedies would be effective in that the department would certainly not continue along the line it has been continuing for 4 years. My lady, just a moment. My lady, at the death of these events, there were further inexcusable delays, which I have to raise. It's all relevant to urgency, which your ladyship must consider. I'm going to point to 2 delays, and I ask your ladyship to consider this in the context of no spatium deliberandi and 3 days to file. The first is, my lady, after the 10-month period, the applicant drafts and signs its enforcement order on the 6th of November. They only served it on the 18th of November. Well, a proper enforcement order was only served 12 days after the enforcement document was signed. 12 days. That is an enormous waste of time in the context of the chronology of these events. That was the first delay. Then the second delay was the applicant should have realized that the 30-day period have transpired and there is no appeal. And now I must just make certain of my dates. My lady, the 30-day period expired. Remember, this is now counting from the 18th of November. It expired on the 17th of December. On the 17th of December, there was no appeal. There was no application. The application was launched 10 days later on the 27th of December. So add to the 12 days I've dealt with, this 10-day period, the applicant through inaction caused a delay of 12 plus 10, i.e. 22 days, 3 weeks. Small wonder that when papers are exchanged, it results in the mess that is before your ladyship. No practice directive and no heads of argument until at a very late stage, when it was so very inconvenient to the respondents. So, my lady, I submit that all deals with the urgency. I submit, my lady, that in the circumstances your ladyship should find that the application does not deserve the attention of this court because of a lack of urgency, and I assume that your ladyship will then probably strike it from the roll, and I ask your ladyship to order that the applicant pay the costs of the third, fourth and fifth respondent on the basis set out in our answering affidavit, i.e. Section C. Scale C. Not Section C, Scale C, my lady. I assume the same holds true for my learned friend, that he also asked for costs on Scale C. As the court
Thank you,
pleases,
Mr.
madam.
Belser. Mr. Tswane?
May I please record my bit? Lady, I am tempted to read the book of Van Black, but I think the answer to the question about the relief that was sought and that was granted, and why it was granted in the manner in which it was granted, appears from the papers of the AfriForum respondents. Can I refer my lady to page 3-56 on case lines, because
Page 3? Oh,
3-56.
56.
And that is the practice note and short heads of argument on behalf of the applicants in the application before Justice Miller. You will see, I don't know if my lady is there yet.
I'm there.
Yeah, my lady will see in paragraph 5.1 how the order came about and why the general declarator, why the general declaratory order was not granted in the first place. So the first, second, and fourth respondents agreed to the relief that was being sought, provided the general declaratory order was not going to be granted. That is why it was not granted. So it is not because of the drafting of the notice of motion and how one does these things in a review application. So that, my lady, applies to the first, third, and fourth respondents. And in that paragraph, my lady, you will see that the applicant said the applicants indeed persist only with that relief. And when it relates to my client, paragraph 5.2, again the same concern was raised, that we will abide provided the general declaratory order was not granted. And they agreed. And that is why we say today that that order does not prevent the regulator from conducting the assessment which it did.
I don't think that's the argument. I think everyone accepts that she can conduct the assessment. The question is whether, under these circumstances, in the light of the order, and remember we're now just busy with the urgency,
Well,
whether
I mean,
under these circumstances, whether she could have conducted the assessment, if that is in dispute, it can be dealt with dispute, it can be dealt with